My name is DARYL Atkinson, co-director of Forward Justice, and I'll be your moderator for this morning's panel. And we're looking at innovation in litigation. And I'm part of the steering committee, and I can tell you a little inside baseball. I fought for this panel because litigation has really emerged as one of the potent tools in spurring innovation around the country in kind of pushing criminal justice reform and smart on crime innovation forward. We have a wonderful panel this morning. We have Eric Halperin from the Civil Rights Corps. We have EZEKIEL Edwards from ACLU Criminal Law Project. We have Jen Lee from NAACP-LDF, and we have SONJA TONNESEN from Root and Rebound. And so just kind of some initial framing. We're seeing around the country, whether it's front end of the system issues around bail, around police accountability, that litigation can be a potent tool to holding the system accountable, to be fair, smart, and just. We're also seeing this on the back end of the system, and with folks' work around cleaning up erroneous criminal records and making opportunity available for people with regards to employment and the employment context under the EEOC or Fair Housing Act. So litigation is a potent tool to spur innovation, and our panelists are going to talk about some of their work. So run of show will go, each one will have about 8 minutes or so to kind of talk to you all about the scope of their work and some of the things that they're seeing on the ground with regards to opportunity when it comes to litigation for making change. And then we're going to have a little rapid fire question, then we're going to open it up to the audience and have a conversation. Sound good? Are you all awake? All right. We're going to start with Eric Halperin, and then we'll just go in the order of the seating. And here we go.
Good morning, everybody. My name is Eric Halpern. I'm with the Civil Rights Corps, and we are an organization that looks for places where our society's values don't match up with the practices in the American legal system and bring aggressive reform litigation around the country. So we've been around for 1 year. I've been with the organization for 3 weeks, but I have a lot of experience as a civil rights litigator over the last couple of decades. And in our first year, we have about 20 active cases all around the country on issues involving money bail, fines and fees, and debtors' prisons, private probation companies, and other issues such as the suspension of driver's license for failures to provide fees. And in that first year, we've had some notable successes where litigation has created a real opportunity for change. So just 3 recent examples. This spring, we had a case against the misdemeanor bail system in Harris County, Texas, where Houston is located. And the judge there found that the system violated the Constitution, that there were literally thousands and thousands of constitutional violations, and ordered that they cease operating their misdemeanor bail system in the way they had done it before. And that resulted in thousands of people being released from jail who otherwise would have been sitting in jail simply because they could not pay the bail. In a second case that just recently settled was against a private probation company in Rutherford County, Tennessee, that for years had extorted millions of dollars from poor people in the county for fees involving supervision of probation and other issues. And they agreed to a settlement. They agreed to pay $14 million. That money will go to tens of thousands of people who were victimized, and importantly, the county agreed never to contract with a private probation company again and end their requirement of people being placed on parole supervision for failure to pay court fees. So it resulted in change in policy. And then just last week, in a case in Tennessee challenging the practice of suspending driver's license for people who failed to pay traffic fines, the court ordered that our 2 clients, it's a class action, but the named clients have their driver's license reinstated and granted a temporary restraining order involving that law. And that is a case where 250,000 people in Tennessee have had their driver's license suspended, which means in Tennessee, where there's not a public transportation system that one can rely on, you're cut off from access to food, employment, daycare, really a lot of the basic necessities of life simply because you were too poor to pay your traffic fees. And so obviously it's a policy that makes no sense on any measure and is just simply wrong and immoral. So, and those are places where litigation has worked. And even though litigation can do a lot of good, it rarely succeeds in a vacuum outside of other tactics of advocacy, other tools. And as a relatively new organization, what we're trying to figure out is how we can make sure our litigation is a part of a broader set of array of advocacy tools that really help build power in impacted communities and change policies over the long run. Courts are inherently sort of conservative institutions. They do respond to changes to political pressure, to changes in culture and narrative, but they're rarely going to be the actors who are going to lead society in a place where maybe there aren't already people who are going there. And so when we think about sort of what would be a successful litigation strategy, for us, it has to also involve things that are happening outside of the courtroom. And I think it provides, like litigation at its best, provides a locus or like a focus point where organizers, members of the community, journalists can engage on a problem. It provides sort of a place where people can gather around, if you will, publicly and talk about it. It brings practices to light that otherwise were hidden. It forces public officials to explain why they enacted those policies. It reveals often that they had no real factual basis for believing the policies do what they say it does, or they had no legal basis. It's a forcing mechanism to force them to do that. And then when it's successful, it can hold people accountable. But when we think about the great litigation victories, like the recent one in marriage equity or the civil rights victories of the 50s and 60s, I know people in this room probably don't think about them this way, but sometimes lawyers think about, it was all because of what happened in the courtroom. But in each of those cases, right, there were movements happening outside the courtroom that definitely impacted the decisions that were made. And so I think that's our challenge, is how can we do that here? How can we do that in the context of the issues that we all care about? Because if we're really, for courts, especially courts are deeply invested in the status quo of the criminal system. A lot of them have been involved as judges or in other places in the criminal system for a long time before our cases get to them. So if we really want to change the views, we really have to think about changing how society views, what the societal view and narrative around jailing people in the United States. That's ultimately what will be connected to litigation victories. So like a couple of examples of places where we think we've done a good job of doing that, and things that we want to do more of as we move forward with our litigation. Harris County really represents a great example for us. We worked very closely with organizers on the ground there, including the Texas Organizing Project. And from the beginning of the case, we are engaged with community members, learning about their stories, elevating their stories, using that to inform our litigation. As part of that litigation, some videos of the bail system really in action came out, which were very powerful. They showed really what it was like for people who were brought in front of those hearing officers, their 1-minute hearing without a lawyer, without any representation, without any regard to whether they could pay the bail, no inquiry into their financial circumstances or really anything at all. Just very summary decisions, really a factory, moving bodies through. And those videos were widely publicized by advocates on the ground and became a big part of local elections in November 2016, where candidates who ran on bail reform won, and the videos were a part of that. And so that's like a place where, not only is there the press strategy, and that's one thing litigation's really good at, is getting press to cover cases and getting voices in there, but that was where it also, obviously, it played a role in elections too. So that's an ultimate accountability measure. And then litigation also can provide an opportunity for other voices to come out. So your unlikely allies, your judges who want to change the system, or law enforcement, they can do that sometimes through statements to the press or through filing amicus briefs that then get covered by the press. And I think that's a really important piece of changing sort of the overall culture and narrative. And then one other example, because one of the things about litigation is, as lawyers, so we win and we think of like the case ends when we either settle it or when we get an order. But really for people in the community, that's when the work really starts. And so one of the challenges always is, how can you build mechanisms into settlements or resolutions that build power in communities and provide mechanisms for people to sort of keep working on the issues going forward. And in our settlement against Jennings, Missouri, for its poverty jailing practices, We had a $4.5 million settlement. Much of that money went to individuals, but also some of that money was used to hire organizers to go door to door, looking for people who were illegally jailed, who would qualify under the settlement, but also that provided an opportunity for them to have conversations on doorsteps, to build support for the reforms. Because really, it's an ongoing process. It rarely ends when the litigation ends. So I think that's sort of is the key challenge for us in litigation, and how to think about litigation as part of a broader strategy. And I think it's particularly important for these issues because, of course, to win any of our cases, we're going to need like unassailable legal arguments, meticulous factual records. But then if we also don't have it paired with these other types of activities, our success will be limited. So that sort of is what we're thinking about. I think that's how we can think about litigation as sort of part of all these other strategies that we've heard about over the course of the couple of days of this conference.
Thank you for that, Eric. Before we go to SONJA, I want to highlight one of the points that you made because I think it's a good segue to SONJA's work, where she talked about root and rebound play an essential role in the implementation. So, Eric, you talked about the case doesn't end for the people after the legal case ends, right? Then that's where the implementation and some of those issues really start to play out. SONJA, and you talked about in our preparation for this panel some of Root and Rebound's work and really kind of playing that implemental role once a public policy has been enacted. And litigation is just another form of implementing public policy through the courts, right? And so can you talk a little bit about that? I think you want to start us off with a video. Is that right?
Yeah. Well, thank you very much for that segue, and I'm really excited to be up here with DARYL and Eric and Zeke and Jin. I'm not here as an experienced litigator. I am here much more as someone who is an experienced listener and is close to the ground when a lot of these issues are happening. Also a lawyer, and so I wanted to, before I dove into what Root and Rebound does, share a video from two of our clients about a legal obstacle that they confronted and a bit about how Root and Rebound worked with them. So I'm going to have our wonderful support cue that up. Okay. Thank you.
My name's Petra Gabriel. I've been out 18 months. My release date was June 7th, 2014.
Minister Joseph Gabriel, Mount Sinai Baptist Church. I was introduced to Root and Rebound during the time where we were having some problems dealing with parole. One of the stipulations on Petra's parole was that she could not be around me. She had a stay-away order. And my parole plans did not stipulate I had to stay away from her. It shows that it wasn't something that had to be done because of it had to be done. If it was the legalities of it, they would have put it in my parole plans also.
It really, it devastated me. I'm diagnosed bipolar type 2, and I have ADHD. I have severe anxiety. Well, during my incarceration, they would not give me the right medications. I can't function unless I have my medication. I can't. And for them to just take it away from me and leave me in a violent situation for 3.5 years, there's no way. And my parole agent actually said that he would not approve me to start taking my medications again because that means I would test dirty. And he didn't want to go through the hassle of having to deal with explaining why I had dirty tests. For the first 3 months I was out, I was a shell of a person when I got out. And then not being able to go to the one person that has always been there for me, that was the person who would make sure that I was okay. So it was very hard. It was extremely hard.
You think about the correctional department. Recently they went from CDC to CDCR, which the R stands for rehabilitation. Right. In the process of rehabilitation, there's family reunification. Right. Kind of weird that you put a stay-away order on two individuals that have been married for 16 years.
Okay, thank you for sharing that. So I wanted to bring the voices of our clients here because oftentimes they can't actually be here physically present. Often, especially if you're on parole or probation, it can be really difficult to travel. So I wanted to bring their voices front and center and to sort of highlight some of the issues that come up in our work. So I'm going to tell you a bit about what Root and Rebound does and why, and then I wanted to return to some of the themes and the issues that came up in the video. So Root and Rebound is a nonprofit organization. We're based in Oakland. We work statewide in California, really trying to increase access to justice and to opportunity for people in reentry from prison and jail and for people with criminal records, whether or not they ever stepped foot in prison or jail. And yesterday, through DARYL's words, through many of the speakers, from the wonderful gentleman whose company served us lunch, we heard a lot from people about some of those obstacles that occur. And a lot of those obstacles that occur post-release or when you have a criminal record are legal obstacles. They're completely lawful. And that's really problematic. If people have already served their time and they continue to be punished for the rest of their life, reunifying with family, just trying to get around in the world, trying to be healthy, take medication, things that so many of us take for granted. So we, as a legal organization, work to provide expertise to people impacted by the criminal justice system about their rights with a criminal record. And also to their family members. We see that family members are often the front line of advocacy for their loved ones who are incarcerated, but don't have the legal resources, the information. You know, there's so many issues that we all might just go online and Google, right? Like, you may have a doctor who gives you advice if you're pregnant, but you're like, I'm going to still research this myself and go look at blogs and find out information and read up on the science. And I think there's been an assumption, which is completely unfair, that people in prison or people who've been previously incarcerated aren't entitled to that same kind of information about their rights, that they're not sophisticated enough to understand the law, know the law, advocate for themselves when they have it at their fingertips. So we really want to turn that belief system upside down at Root and Rebound, that people have the right to know their rights, that they have the right to advocate for themselves and their families, and that when you've served your time, it should be done. Yesterday, Mr. Cobb from the ACLU, actually, who was on the panel about reentry and criminal records, he said, let's stop saying we give people second chances. They've earned their second chance. They've earned whatever chance it is. They've already served time. Why do we continue to punish people? So let's stop saying we give second chances. People earn them. So that's really the work that we do. And we actually run one of the only, I believe the only hotline in the entire country for people to call in with legal questions about criminal records. And that connects a lot with the litigation issue, because as lawyers, we get about 100 calls every Friday on our reentry legal hotline from people experiencing these kinds of barriers, looking for legal advice, looking for legal assistance. And we're a small organization. We were founded in 2013, so we're about 4 years old. And as we just heard, it's resource intensive to bring lawsuits. So for our organization and organizations like ours that go inside the prisons and jails, that are on the ground hearing about the obstacles firsthand, and that are legally trained so we can identify some of the issues, it's critical for us to hold hands with people who have the resources and the experience as litigators to bring forward a lot of these injustices. And a couple examples I wanted to give. One is around voting. So in California, for those of you who have been familiar with the voting rights work, organizations like All of Us or None, Legal Services for Prisoners with Children, in partnership with larger groups like the ACLU, worked to litigate people's right to vote when you had a criminal record, right? There was some debate around, it's called realignment in California, and it changed the way a lot of people were sentenced, putting a lot of the correctional control at the county level and taking it away from the states, right? So more people going into our county jails who would have previously been sentenced to prison, more people going out onto county probation who would have previously been on state supervision, state parole. So there was this county local control happening. And there was some confusion when all these sentencing changes happen and a change in our correctional system. Can people still vote? What does our law say on this? And the way it was being practiced was that many people were being disenfranchised. And so there was litigation brought against the Secretary of State at the time saying, no, under our law, we believe that this group of people who have been now recategorized under the law should have the right to vote. And that litigation, which took a lot of time and a lot of resources and a lot of public communications, was eventually successful. And not only was it successful in re-enfranchising, if that's the word, many people with the right to vote who were sentenced under realignment, who were in the county jails, who were in the community, but it also paved the way for an additional change, which was through the legislation, through legislator. So we actually had the following year after that litigation, a bill that was introduced, even further opening up, broadening the definition of who can vote in California. And that legislation was successful. I'm not sure that that would have been as successful had litigation not paved the way the year before, had community organizers not brought the issue to litigators. So it's sort of this stream of events where I feel that we're all really deeply connected in our work, even if we're playing it at different roles, but it's important for us to hold hands. One of the issues around implementation in that case that DARYL mentioned is that in very recent times, it has come to our attention through our hotline, and also because we communicate through legal mail with people while they're incarcerated. So we get about 500 letters per week from people currently incarcerated across the state of California. And we learn a lot about the abuses and the issues going on there, but also about when policy changes, how is it actually being implemented inside? And we learned that there is very, very, not shockingly, I guess, but very little access to actually voting inside jails, inside county jails. There's 58 counties in California. Many of them are very rural, very conservative counties. It's not the California of the movies. So getting folks the right was one thing. Getting people the access is a totally different thing. And that's where we believe that lawyers, community organizers, advocates going inside on the ground can play a big role in bringing litigation to life. It's sort of that third leg of the triathlon, right? Big reform happens, but it means nothing if it's not being implemented. There's no right if people can't access it. So that's a lot of the work we do. And before I quickly transition back to DARYL, I wanted to return to the video and open it up really quickly to the audience, just very quick popcorn, one sentence. If you're a lawyer, it can be a legal thing. What are some just like immediate reactions to the story you heard from Petra and Pastor Joe? Just shout it out. You don't have to raise your hand or anything. Don't worry. Access to medicine, right? That was concerning. Anything else? Like, what were issues that they were dealing with? And if you're a lawyer, were there laws that you're worried about? Access to a support system, right? Family members. Yeah, their marriage, right? There's this right to marriage. Isn't that a thing in the law? And they couldn't see each other. So those are all great points, and that's part of the reason I shared it. One is because I think education is powerful, and that was proof. This husband and wife came to Root and Rebound saying, it doesn't seem legal if we were co-defendants with the exact same crime and we were able to see each other while we were incarcerated and have conjugal visits, that we can't see each other, talk to each other, write a letter to each other on our 3-year parole term. But not only that, I don't know if you caught this in the video, only the wife had that role, not the husband. Same conviction, different parole officer, same conviction, same sentence, co-defendants. This was not a conspired crime, but he said it. The legality of it doesn't make sense. If it was a legal necessity, we would both have it. If it were a public safety necessity, we would both have it, but only the wife had it. So that was the grounds that we used to appeal that condition and be successful. But then what happened? And this is why you have to keep going. You can't leave clients at the first stop. Then they retaliated, and they put an ankle monitor on her. And they said they had a quota. They had to fill their quota of ankle monitors. That is so not okay. No. So you have to stick with people, and new issues sort of start to masquerade themselves. But this is an issue I wanted to also share because it's something we believe that litigators could take up, is around, we've talked a lot around the discretion in policing and models of policing. In the same way, DARYL in our prep call said that the criminal justice system operates under the cover of darkness. Nothing could be more true than for parole and probation and community supervision. There are decisions made, not always out of malice, but sometimes out of malice, just that are totally illegal. And there is no one watching that. There's no one enforcing that. Well, that's not true. There's people being impacted watching it. And so we, as lawyers, I think, need to help litigate it and enforce those issues when we see them. So thank you guys again for having me, and I'm looking forward to the conversation with the audience.
No, thank you, Sonya, for bringing the voices of directly impacted folks into the room. And thank you for that pop quiz that you gave the audience. I bet you all didn't know when you watched that video that it was going to be a test after it on issue spotting. So I appreciate that. That keeps everybody on their toes. We're about to go to Jen now. Jen, in our prep call, you talked about the importance of communications, the importance of you all having an in-house organizer to make your litigation efforts more impactful. Can you expand upon that a little bit?
Sure. Just to begin with, just to give you some background information about where I work. So I work at the NAACP Legal Defense Fund, which is a separate organization from the NAACP. We split many, many years ago, but we are the organization led by Thurgood Marshall, and our office focuses on racial justice litigation. We do a number of different types of litigation. We do education, voting rights, economic justice, but one of our key main areas is criminal justice reform. And that has been something that has been a part of LDF from its very beginning. And we've been around for over 70 years, 75, almost 80 years. And that litigation, can be death penalty litigation, juvenile life without parole. But for the past 10 years, I have been involved in police reform litigation here in New York City to reform the New York City Police Department on how it polices public housing residences. And I did say 10 years, so that is one thing about large-scale litigation, is that it can be very long, can be very resource-intensive, and it is not the most efficient way of achieving reform, which is why I think, and I agree with what's been said wholeheartedly, that it's impossible to get the changes that we want through litigation by itself. It has to be a part of a larger movement in order to get everything that we want to achieve. And I wanted to get to the point about the organizers, but I think it would help to give some context about what our case was about. And this was a situation for many years, decades in fact, of public housing residents and their visitors being unlawfully stopped or arrested for trespass. And in New York City, police officers are permitted to patrol inside the buildings. So trespass was a very common charge that they would arrest people for. And what we saw was that situations where even residents would be arrested for trespassing inside their own apartment building. So if you can imagine that, this is your home, this is a place of all places where you should feel safe, and yet you are being not only harassed by a police officer, but arrested for trespassing inside your own home. And the reason we took this on was because we really saw this as a racial justice issue. Public housing in New York City is over 95% Black and Latino, so it's a very identifiable community of color. The disparities, the racial disparities in the enforcement activity is very stark. At the time we filed our litigation, Blacks and Latinos made up 54% of the city population, but 90% of trespass arrests in New York City. And Black residents were stopped for trespassing in New York City at a rate that's 19 times higher than white New York City residents, and arrested at a rate that was 10 times higher. So this was really, a very, very stark disparity in terms of how police officers were engaging with people on this issue. And some of the stories that came from this case is really, really shocking. One of our clients, he is a young Black man who had lived in his apartment building pretty much his entire life since he was 3 years old, since he was with his grandmother, and a recent college graduate, no criminal record, kind of this, what you would see as a model person, right? This is someone who is really becoming a success story, and he was arrested for trespassing in his own building because he was in the stairwell with a friend, downloading music from his laptop into an iPod. And they said that he didn't have identification on him. He was in the stairwell. The police officer said, you're going to be arrested for trespassing. And then the collateral consequences of that are severe. I mean, for the police officer, and there was a conversation between my client and the police officer's like, oh, it's no big deal. You just go to the precinct and tell them what happened, and, you can get your arrest voided and so forth. But, this is someone who had never had any contact with the police, and yet he was taken to the precinct. He was fingerprinted, kept in a holding cell. The arrest was on his record. He had actually been working at the Harlem Children's Zone, So he was working with children, which alerted his employer. So now his employer had found out he was arrested, and the embarrassment of that, getting his record cleared, even though the charges were immediately dismissed, with all of these collateral consequences, and also the trauma of it. This happened in his own home, the place that he lived in since he was 3 years old, and yet from then on, just the way he viewed police officers, even he has a fear of walking in stairwells from that experience. And that's just one example of many, many hundreds of examples of people who had been abused by the police in public housing. So there were two things that I kind of wanted to raise about the case that I think would be really helpful for people to learn, in terms of things that we learned. One is that we wanted to make this case not just about the people who are actually stopped and arrested, but about also the public housing residents themselves. So that, so we brought claims, saying that there was a Fourth Amendment violation because police were stopping and arresting people without the requisite level of evidence of wrongdoing. And we also brought equal protection claims, saying this was discrimination because they were really focusing this type of activity on a Black and Latino community. But we also brought fair housing claims, and that was based on the fact that the public housing residents themselves, when they're, they have the right to be able to live in their apartment just as anyone else does. And one of the services that they get, one of these municipal services they get from the city is police services. And the police services they were getting was obviously much worse than, New York City residents in, Midtown Manhattan, for example. And so we said that was a form of discrimination. And what that allowed us to do is to kind of present this not as an issue for the individual person who had this interaction with police, but this was actually a community issue. It involved the entire public housing community. And that and the harms of what the police department was doing was far greater than just that one particular arrest or that one particular stop, but it was harming the entire, community of public housing residents. And the other thing that we've learned from our litigation is the importance of identifying what the remedies are very early on. And when I say remedies, it's like at the end of the day, if you win a trial, if you win and you settle your case, what is the change that you want? And oftentimes I think lawyers don't really think about that right away. They're more focused on winning the case. But the importance of knowing what it is that you want to achieve is so critical, because that is really going to be shaped by the claims that you file in your lawsuit, in your complaint, right? That's going to really kind of limit what it is that that you can get at the end of the day. And this is where I think the work that we have, we're very lucky to have an organizer on staff. His name is Marquis Jenkins. He actually grew up in public housing and was originally a public housing organizer. And this is something that is not only kind of a professional issue for him, it's a deep personal issue because his family continues to live in public housing. But he and I have been working very closely for at least the past, 5 or 6 years. And it's so critical for us to have this communication between the lawyers and the organizers, because I can say, well, our case is limited to trespass arrests and trespass stops in public housing residents. That's obviously not how public housing residents think about the problems with police. They're thinking about issues of excessive force. They're concerned about these mass marijuana arrests. There's a host of issues. They're also concerned about having family members not be able to return to public housing because they had spent some time in prison. Just a host of issues, and so and as lawyers, obviously we're not able to address all of these issues, but it's really important for us in terms of credibility with the communities that we're serving that we have this communication so they understand what the litigation is about, but that in terms of advocacy is not limited to litigation, and that's where organizers I think are very critical, because they're not limited to the claims that we filed in our complaint. They're able to kind of organize and advance reform that is much broader than our litigation. And so that's why I think it's very critical for litigation to be paired with organizing, to be paired with a communication strategy, to be paired with policy making and legislative change. And obviously, in order to get the results that we want, to get the remedies that we want, it is absolutely essential to have these deep and meaningful and kind of mutually synergistic relationships with community members. And one, in terms of figuring out what it is that you want to achieve, because as lawyers, we can sit in our office and say, oh, this is something that we can win in court. But if we win in court and it means absolutely nothing to the people on the ground, then what's the point of having spent all this money on litigation? There may be times when there need to be compromises made, or there may be different strategies to take. And when we make those kinds of decisions, it's absolutely essential to have these kind of communications with people on the ground in the community. One of the things that we have learned, that we've done in our case, is Marquis Jenkins, our organizer, has developed a community roundtable of public housing residents. So our case right now was settled. It was settled 2 years ago, and we're part of this large-scale effort. There's a court monitoring of the New York City Police Department, also connected with the Floyd stop and frisk case that was brought by the Center for Constitutional Rights. And it's a very complicated process, reforming, when you think about reforming such a large police department. But what we've done in terms of our community outreach is that Marquis has developed a community roundtable comprised of public housing residents and public housing residential leaders. And we meet with them periodically. We tell them about our case. We ask them questions about, what changes have they seen? The reforms that we think we've made, are they really happening on the ground? We ask them, like, what are some of the problems that you've been seeing on the ground? And in many ways, they are the experts in terms of whether our remedies and our reforms are actually working or actually things that we should be pursuing. So those are some of the things that I think has been just so critical. And I know that not every organization, especially a litigation organization, has the benefit of having an organizer on staff. But that's also why I think lawyers should partner with other community-based organizations. One of the probably the main reason why stop and frisk changed in New York City, one was because of the amazing litigation that was brought by the Center for Constitutional Rights. But I think even more than that was the incredible organizing that happened in New York City that preceded the litigation. And there was a citywide coalition called the Communities United for Police Reform that's comprised of advocacy organizations like us, the Legal Defense Fund, but also these mom and pop community-based organizations that are directly working with the people most affected by police abuse. And it's because of having the citywide coalition where we were really able to not only make change in the courtroom, but also in terms of how the media covers policing in New York City, and passing, successfully passing legislation in the New York City Council. So all of those things together, I think, has what made us achieve the progress that we have made in New York City, although there is much more to do. So thank you for that.
Thank you, Jen. I want to highlight a couple of final points that I took notes on in your presentation. You talked about making the case bigger than the arrestees and making it about all of the residents who lived in public housing. And I think that's an excellent example of how even in the litigation strategy, we're thinking about narrative and expanding the conception of who the potential client base is and who this is impacting. So I really appreciate that final point. And you also highlighted centralizing the issue of racial justice. And I'm about to segue to Zeke. Zeke, one of the things that I took in our notes in our prep call, you talked about, that stood out for me, you talked about the courtroom being a place where the devaluation of black life, you see it up close and personal every day. And so could you comment a little bit about how the ACLU thinks about doing their work from a racial justice frame, economic justice frame, and then we'll kind of build from there.
Sure. Good morning. I'm Zeke Edwards. I'm the director of the ACLU's Criminal Law Reform Project. We do a range of criminal justice work. We're not the only project at the ACLU doing criminal law reform, but that's the central calling of our mandate. I just wanted to make a point about culture change in litigation. Just actually, it wasn't how I was going to start, but based on previous comments, I think Eric highlighted same-sex marriage as an example, but I just wanted to amplify that and then frame it in criminal justice. As many folks here may know, in 1972, the ACLU asked the Supreme Court essentially the exact same question that it asked again in 2015, whether the 14th Amendment protected the right of same-sex couples to marry. And it was a case out of Minnesota. And in a one line, I think, a one-sentence decision by the Supreme Court, it basically said this isn't a federal question. That was it. That was the end of the issue. Forward ahead 40 years, exact same question goes to the Supreme Court in 2015, and they issue a 28-page resounding decision saying that the 14th Amendment does protect that right. And so obviously one has to ask what changed. The legal arguments didn't change. The Constitution didn't change. But certainly the decision changed. And that was because of massive organizing and culture change over those 40 years. And so I think Eric asks the question, how do we do that in the criminal justice system? And I think that's a very good question. Of course, there's not one case that the Supreme Court could decide that would give us all the rights that we need and all the reform that we need. So it's a slightly different strategy. But I do think clearly the organizing, the communications work, the public education work, which I think all of these organizations work so hard on, is fundamental if you want the litigation really to mean anything. I thought about a couple things in thinking about this panel. One, as some folks know, since Donald Trump took power in this country, the ACLU has been very, very busy. If you look at lawsuits and FOIA litigation and EEOC filings, I think right now we're at 103 that we have generated just since November. So people often ask me, who don't work at the ACLU, wow, you at the Criminal Law Reform Project must be just so much busier now under the Trump administration. And kind of depressingly, my answer is no, we're not. We're as busy as we were before. Because the truth is, the criminal justice system, this kind of giant, almost self-sustaining entity, has been grinding along relentlessly in this country, as folks here know now, for 40 years plus. And while it's not to suggest that federal policies, certainly in federal prisons, aren't important, federal funding streams, or that who's in the Oval Office makes no difference, or at DOJ, the truth is we've been doing the exact same amount of hard work now as we were before, because whether it was under President Reagan or Clinton or both Bushes or Obama or Trump, the kind of assault on poor communities and communities of color by this criminal justice system has been relentless. And so I always disappoint people when I say, nope, we're actually not busier. We're as busy as before, and I think people are often a little bit confused. The other thing I thought about when I thought about smart on crime, and maybe this point was made yesterday, unfortunately I couldn't be here. You know, a lot of people I think hear the word crime and they think about, you know, street crimes and public safety in that sense, and how are we smart about it? I don't think they think much about environmental crimes or corporate crimes. But they also, I don't think, but what I thought about, they don't think about the crimes that are perpetrated by our criminal punishment system, the kind of systematic degradation and exclusion from political life of poor people, particularly people of color, that is perpetrated by our criminal justice system. So when I think about smart on crime, I think about smart on about those kinds of crimes, really state-sponsored, often violent crimes that we commit in the name of criminal law and ironically in public safety. And I think it's important because not only are those crimes immoral and unconstitutional, but they also are criminogenic, right? They both create cultures in local and state governments that allow abuses of authority to flourish. And then they also, in terms of the harms they cause to individuals and families and communities, result in more crime in those communities and keep people cycling through the criminal justice system. So we frame our litigation work, I think, around two major themes in terms of state-sponsored crime in that sense. One we do very explicitly, one we kind of do mostly in my head, but we still do it. So one is, I think the greatest crime that we've perpetrated is mass incarceration. We all know the statistics. We're the leading incarcerator in the world by far and have been for many years. We incarcerate more people for much longer and in much harsher conditions than really almost any other country, and in some ways more than any other country. So that to me is the greatest offense that this country has engaged in, and is arguably the largest domestic crime that this country has committed, at least in my generation. So we are in the midst at the ACLU of a smart justice campaign, which is aimed at reducing our incarcerated population by 50%. And we do that through a variety of means, as we've talked about: public education, legislation, certainly communication, but also through litigation. And so we are focusing some of our litigation on what we think are the drivers of this crime of mass incarceration. One area is pretrial justice, with a real emphasis on bail reform. The work of Civil Rights Corps that Eric talked about, of ATKINSON, has been really groundbreaking in that area. We are partnering with Civil Rights Corps and then bringing our own litigation to reduce this country's pretrial detention population. It's 750,000 people are in our jails. 2/3 of them are unconvicted. If you took our unconvicted detained population, we'd have, at least as of a couple years ago, the 4th largest prison population in the world. So we're going after unconstitutional detention policies around the country. That includes, again, what Civil Rights Corps has been leading on, which is going after money bail and misdemeanor detention. But we're also going after felony bail practices. We're going after the conditions of release that are onerous, that ultimately put people back in jail. We're going after the privatization of probation. And also we are going to be really digging down into the $2 billion for-profit bail bond industry and going after them in, I think, a bunch of different ways, other than just in the kind of traditional bail reform ways that we've seen, because that is really the source in many ways of these problems. So that's one area. Another driver of incarceration that we are really ramping up, that I think has laid dormant for way too long, are prosecutors. Let's be clear. Progressive prosecutors who we work with can make a world of difference in incarceration rates and in constitutional rights. And we want to work with those progressive prosecutors, and we want those prosecutors to get into office to affect change. But there are so many places where those are not the prosecutors who are running the district attorney's office. And I think for a long time people thought, well, you can't really litigate against prosecutors because basically they're immune, and so people just don't explore it. We're going to change that. And I think the kind of, reverberations that have spread throughout the country with some of the political campaigns where progressive prosecutors running on smart platforms have gotten elected, and has really kind of, I think, shaken up that profession. We're going to try to do the same through litigation. Some of it is going to be innovative, some of it is going to be rehashing old territory. So those are two places where I think we're really excited to do litigation. The other kind of thematic area where I said it's kind of mostly in my head, but which was also referenced by the other panelists, is the degradation of human dignity, of poor life, and of black life. And if you go around to courts around this country, there's been a lot of talk about the devaluation of black life because of the horrific police shootings, so many of which have been caught on video. What doesn't get caught on video and happens actually far more often, and I think lays the terrain for those kinds of police shootings, is the same devaluation of poor and black life in our courtrooms every day, where people are belittled, where their dignity is stepped upon, where their constitutional rights are ignored. And so we are targeting litigation in some of those places. In Scott County, Mississippi, they were arresting people, detaining them without proper bail procedures, and then holding them indefinitely, not formally charging them and not giving them counsel. Our lead plaintiff was arrested 3 times and spent 3 out of 5 years incarcerated without ever being formally charged and without ever being given a lawyer, largely because the judge in that county decided, in fact, he said in an Al Jazeera interview, well, these are criminals, so they don't have the same rights. So he wouldn't appoint counsel until they were indicted, and the prosecutors had no time limit upon which they had to indict people. So we sued, and we've changed that practice there. In Lexington County, South Carolina, they run a debtor's prison. People are getting incarcerated for 50 to 60 days solely because they can't afford to pay a fine or fee without a hearing to determine their ability or efforts to pay, and without counsel. So we sued there. In Miami, if they decide they're not going to incarcerate you, the prosecutor, the judge removes your public defender who's been working on your case, filing motions. You're about to go to trial. He kicks the public defender off the case, leaves you by yourself to negotiate a plea or go to trial. There are many more examples like this. When I was thinking of the example of getting arrested for trespass in your own building, when I was a public defender in the Bronx, I represented several people who were arrested for trespass in their own building. You know, kids who are arrested for using their Metro card on election day, to teenagers who were thrown in jail. A woman who switched train cars to get away from a man who was harassing her and was arrested and thrown in jail and missed a day of work because she was moving between subway cars. I mean, these are the kinds of devaluation and degradation that happen not on videotape. And much of our litigation, obviously we bring it usually as class actions to change practices, but it's going after the dark side of the criminal justice system, which is most of it that lays unseen. And so I can talk more a little bit about specific cases, but those are kind of the themes of where our litigation is focused. It's going to be focused there for, unfortunately, for several years to come, because as I said, I don't think those things are changing fast enough.
Thank you for that, Zeke. Awesome, awesome. We're going to have a quick popcorn round, and then we're going to open it up to the audience. Jen, I want to circle back to you, and you talked about the importance of what I would characterize as feedback loops with community about the construction of remedies. Can you talk a little bit about, let's concretize that. How do we do that? How do you set up those kind of systems, what I think of as accountability, because folks can be in their office constructing remedies thinking that this is a good outcome for the case without ever talking to the people that is actually going to be impacted by it. Yeah. So can you talk a little bit about creating those feedback loops and how important they are?
Well, I mean, that's exactly what we've been trying to do in our case. Some of this is just actually having communications, because it's amazing how many times lawyers just don't even communicate to community members or even their clients about all the things that are going on in their case. And, you know, and I understand that lawyers can get very busy and some things are very complicated to explain, but I think that it's absolutely essential to maintain that communication. And it's somewhat condescending to think that somehow that communication is not necessary and that perhaps people don't understand it or it's too complicated for them. You know, I'm not of that mind at all. I think that if it's too complicated, that means that you're not explaining it very well. And so, you know, I think that that is absolutely essential. One of the things that is really important, especially in situations like our case where it's a court monitoring. So this is, you know, major police reform. And at some point, the police department is going to want to get out of court supervision. And the question is going to be, have they reformed enough? And the term we've used in our settlement agreement is substantial compliance. And then the question, you know, comes up, how do you measure compliance? How do you measure that there's been enough reform? I mean, clearly they can't be 100% exactly what you want. I mean, there's never going to be a situation where a police department will never, ever make a mistake, but how much reform is enough? I don't know the answer to that question right now, but I do believe that community members have to be a part of that process in some way, because, you know, in some ways we can look at statistics, but there's different ways of analyzing statistics and numbers. At some point there has to be some sort of process of having some sort of qualitative evaluation of the police department in terms of the quality of the policing that's happening and whether that's really changed. Do people on the ground really feel that the police services they're getting is different and substantially better than what they had before? It's not an easy process, you know, and then, you know, the question is like, who is the community and who are the people that we want to be communicating with? And the other challenge that comes up time and time again are that the people who are most affected are people who are most resource strained. they often don't get paid for doing these kinds of things. They don't have the time. They have their own jobs. They have their own lives to lead. If they're a part of a community-based organization, there are 1,000 things that they're addressing. Being a part of a remedial process in a police reform case may not be at the top of their list. And so these are challenges that we have to overcome. But despite these challenges, I think that it's really important to try to make that happen. It may not be perfect, but to kind of ignore that component of police reform, I think, is a tremendous mistake for anyone engaged in litigation.
No, thank you for that. You also mentioned the trajectory of some of these cases, right? I think folks who may not operate in this sphere, particularly people who aren't attorneys, often think of the resolution of a legal issue in the mindset of a Law and Order kind of episode. Like, oh, it happens, then an hour later it's over. But these things last years, right? And you talked about the cost too. And Eric, I want to come back to you. During some of our preparation for this, we talked about the protracted nature of litigation, the cost of it, what I kind of characterize as the price of admission, right? And it's going up more and more to be able to access the federal courts. It's a costly endeavor. You all at Civil Rights Corps have kind of developed some interesting models to be able to absorb those costs in combination with law firms or what have you. Can you lift a few of those models up that people can potentially take away to replicate when they go back home if they want to do this kind of work?
Sure. Yeah. Certainly there's two issues I think that come into play. There's the cost side, and then there's the time side. And Jin's example is of her litigation and how long that takes. That creates both resource constraints, and then it strains your partners on the ground who you're asking to be engaged over such a long period of time. So for us, we do all our cases in partnership with other nonprofits or private law firms. We use a co-counseling model that has been used by years by lots of other people, including people on this panel. We both, in all our cases, we're going to have since we're an organization that's based in Washington, D.C., we're going to have a partner on the ground, usually a nonprofit legal organization, maybe one of the ACLU affiliates. And that's really key, and that's important because you need someone local who gives you that kind of engagement. And then we've also developed, it's challenging sometimes working with pro bono counsel or private firm counsel. Like, they're not always going to be able to engage on their issues. It depends on, in some places they may be conflicted out because maybe they do a lot of representation of the local government, particularly in smaller markets where that's a big part of major firms' business. But we have developed in a number of our cases partnerships with national law firms who have really been a key part of it, especially when you get into discovery. Managing discovery in these complex cases is incredibly expensive. And Baker Donaldson has been with us on the Tennessee cases, both the private probation case and the driver's license case, and they've been very helpful. And a large firm in D.C., Wilmer, helped us on the Fifth Circuit appeal of our case against Harris County. And that was really essential for a small organization like us. And then our partnership with our colleagues, including our colleagues on this panel, is really essential. We've done a number of cases and have a few in the hopper with the ACLU that we're excited about bringing. And even within the nonprofit sector, there's a way to leverage your resources. And I think the other issue is for your local partners over time. How could you sustain engagement with litigation? Because there is this sort of law and order arc, and people, you file and everyone's excited. And then 10 years passes, and then there's moments within that. There can be hearings, but thinking about ways that there's opportunities for community engagement along the way in the process, and like having an organizer is a great luxury, or partnering with organizers on the ground is essential. Can there be actions? Can there be moments either in the litigation or involving if you're challenging money bail, involving the bail system, where you can engage organizers, realizing that it's going to go up and down, and you're not going to be able to ask for people a 10-year high-level engagement, but you need to be communicating and working with them along the way, so when you need them and when you can get their input and get their guidance on the litigation when it's essential.
Awesome. Sure, Zeke.
Just one maybe obvious challenge, because I agree with everything that was just said. There's certain places and issues where I feel like connecting with organizers and communities is much easier. So we're litigating a case against the Milwaukee Police Department, which looks a little bit like the stop and frisk case in New York for race-based stops and bad searches systematically in communities of color in Milwaukee. And that's a fairly major city, a mid-major city with a real organizing presence, and our affiliate is been connected with the community there. And so that's been a productive and essential engagement. But in some of the cases that I just referenced in like rural Mississippi, in small towns, there isn't necessarily the same kind of nonprofit presence. There's not necessarily the same grassroots organizing or money available on the local level for that. And so it doesn't mean we don't bring that litigation, because there are so many bad actors that, as limited a tool as litigation can be, I really think it is essential to go after some of the crimes that are happening. That said, it's also limited because you worry about long-term sustained change in places where you don't have a kind of vibrant community organizing community. And so that's a big challenge. I think particularly in parts of the South, not to generalize too much.
No, great point, great point. Sonya, you talked about Root and Rebound's kind of role on back-end implementation. Can you also talk about your role on front end in ferreting out litigable issues because of the way that you all do your work and the population that you come in contact with?
Yeah. So on the front end, I think I even when we were just sitting and chatting, Eric, I was telling him about how we're meeting plaintiffs every single day. And that's something that large litigation firms don't always have, that same kind of community connection. And again, why I think it's essential to work with groups that are on the ground. We are lawyers, which is kind of a unique perspective, and yet we have massive amounts of communications happening all the time. We've had some interesting cases that are just now starting to be brought by groups like the ACLU in California. An example there was where we heard from a rural community that basically county fair housing plan was not in alignment with the way the city was enforcing local ordinances around people living together who are on probation, right? So we were hearing from a woman of color who runs transitional housing, who has a deep passion for the community that we serve and started this housing for that purpose, that she was getting fined on a weekly basis because basically NIMBYism, right? She was in a white community, in a rural community in California. And so we were able to then connect her with larger litigation firms. Again, because we as an organization, we run trainings across the state of California. We go into rural communities. We take mobile buses up into tribal lands on the border with Oregon. So we're often talking to people who are in those exact situations where they do not have access to a nonprofit. They've never had a clean slate clinic, like LA or Oakland might have on a weekly or monthly basis. So the barriers they've experienced because of their record have never had a name, have never had a movement in their space. And so I think it's really, really critical to we heard yesterday, I forget who brought this up, but talking about getting close to the problem, having proximity to it. If you're litigating, it's very hard to have that, but it's not impossible. Again, I think it's about the relationship building and partners and realizing we have limitations, and including as lawyers in the community that we have limitations. We have things we won't understand that people are experiencing, and giving a lot of deference and validity, hearing people's issues, taking them really seriously, I think is a big part of what we're called upon to do, and acting upon them when we hear it. I think that's another thing that can happen sometimes in policy reform and litigation is things get very sexy. So when new things start to come up, we sort of ignore them because we're like, well, we're working on this case and it's taking all of our time and resources, but we make our time, we make our resources, right? And when we care enough, we find them. So I think always coming from that place of care when someone is expressing an issue, not to write it off, even if it's not in your plan or your strategy or your funding streams or what have you, you have to listen to it. I know that happened for us as an organization. We were doing, we've only been around 4 years, but we were doing little to no immigration legal work. And it wasn't that deportation suddenly went from 0 to 100 when Trump came to power. Mass deportation was happening along with mass incarceration, right? And often for the criminal system involvement for immigrant families and individuals. But the fear factor is what we saw change. Suddenly we were getting at least 20 calls a week mostly from women, but from men and women in ICE detention, calling about their families, wondering what they're going to do, saying, am I going to even get a lawyer in here? Again, it wasn't necessarily that the systems had changed, but the fear became much more intense. And I think if you're an organization that wants to serve the community, you have to be responsive to that and say, okay, we don't know immigration law, then we need to find people who know immigration law, so that we can help folks make a plan for when they come home, or if they're not coming home, what to do. And again, I think that it leads you to new issues. It leads you to new plaintiffs if you're coming with an open mind and an open heart.
No, thank you for that. Jen, I think you want to get in?
Yeah, I just wanted, as people were talking, I was just thinking about the importance of making this distinction about criminal justice reform in urban areas versus rural areas, and they're very different. But I did want to make a case that what we had talked about before about building relationships and making things community-based is possible even in very strapped, in kind of poor rural areas or southern cities that does not have the same resources as places like San Francisco and New York City and Chicago and places like that. And this is a lesson that we've learned at the Legal Defense Fund, because we do a lot of litigation in the South on criminal justice, but also voting and school desegregation. And what we found is that, you may not have a sophisticated community-based organization, but what you often have are very active and vibrant pastors, religious leaders. Usually there's oftentimes strong Black leadership. So we have worked with former Black prosecutors who have gone in to become defense attorneys who pretty much know everyone. And so it's just, once you find that right person, that person knows basically everyone. And just using an example, I have a case in Mississippi, in Jackson, Mississippi, and a client who had a juvenile life without parole sentence, and his middle school principal was very active in helping our case. And it turns out the middle school principal also started this large church and was also very active in the community, and knew pretty much everyone on the parole board, because either their child went to his school when he was a middle school principal, or they had some sort of dealings on some sort of some sort of association or civic association and things like that. So there are these different kinds of networks, I think, in these smaller rural areas that are different than urban areas, but those are things worth tapping into. And the other big resource, of course, is clients, because for someone to become a plaintiff in a lawsuit is in itself a leadership position, and they are someone in the community that can be a tremendous resource for information and guidance on how to kind of navigate the political landscape and so forth. And that's something to think about when we're picking plaintiffs, right? That there's also the kind of the facts, and you want someone who kind of fits well within the claim, but also someone who could be a leader on this issue and a great resource for kind of advising on how the case should proceed.
No, thank you for that. My last question is going to go to Zeke. And Zeke, I heard during some of your comments you revealed that you're a recovering public defender. So am I. We need to have a support group. And I want to highlight some of the work that you talked about that on particularly on access to lawyers in indigent defense. We heard yesterday how in many respects indigent defense lawyers they're the front line, right? And very often they get ignored, particularly in the criminal justice reform kind of conversation, right? Can you talk a little bit about some of the ACLU's work in making indigent defense better?
Sure. Just briefly, I mean, we are in an indigent defense crisis in this country, and I think if you live in New York or you live in Seattle or you live in D.C., you might not think that, because there are fantastic public defender offices strapped, I'm sure, for cash and overworked, but really thriving and doing innovative things. But in most of the country, that is not the case. And there's a range of problems with indigent defense. It goes from the fact that there are courtrooms around this country that are not covered by lawyers, where people are certainly getting prosecuted and lifelong criminal convictions, and in some places getting jailed without ever seeing a lawyer, without ever being told that they have a right to a lawyer. And we're actually hopefully bringing a lawsuit this week challenging a couple of cities in a southern state that just prosecute and jail people without ever giving them counsel. And so that's a big problem. But it's also a big problem even in places where you get a lawyer. Those lawyers in so many places are carrying just stunningly high caseloads. And this could be both, again, in places like Louisiana, but it's also Fresno, California, where the felony caseloads for public defenders a few years ago in Fresno were just astronomical. And so lawyers are just incapable. They don't have the time. They don't have the money. They don't have access to experts. They don't have investigators. They can't go meet their clients. They spend 2 minutes, 3 minutes, 5 minutes, 2 hours per case. And so you find people who are too poor to hire private lawyers sitting in jail saying that they haven't talked to their public defender for 4 months, right? Saying that they have no idea what's going on in their case. So we have brought several lawsuits of different variations. We've brought lawsuits against states or state officials, essentially challenging the fact that states have an obligation under the Sixth Amendment to make sure that everybody, all their citizens' Sixth Amendment right to counsel is being recognized. But states regularly ignore that. They don't. There are states that provide no funding to indigent defense or 10% funding, no oversight and no training. And so while states can delegate that authority to counties and cities, they can't abrogate it. They can't totally ignore it. And many of those places are not holding up their end of the bargain. So we have several lawsuits going in California, in Missouri, in Pennsylvania, in Idaho. We're going to be filing soon in another Western state. And then we also go after what I call these kind of no counsel courts, where there may be a public defender in the state, but they're not showing up in these places. And if you go into those courtrooms, it looks so little like what you think, like what I was used to, even in the Bronx, which had so many problems. You took it for granted that at your first appearance you had a lawyer, that the lawyers would talk to you, that they practice holistic representation, that I had an investigator. None of those things exist in so many places in this country. And just one other quick thing about organizing, tying it to this issue. I agree. So I do think it's harder in certain rural places, but I think Jen's point is well taken. But it's also, I think, that the issues are sometimes a little harder to organize around. I think police shootings, are easier to galvanize kind of community engagement and tie into kind of abuse of police practices over several years or decades. It's a lot easier to do that, I think, though this is changing a little bit, than to do it around bail reform or to do it around indigent defense. When an indigent defense system is crumbling and people don't have good or any lawyers, it's not something, and maybe we should take part of the blame for this, that I feel like there's a real organizing movement around. There's not people marching. There's not a lot of, now there are a few people like Raj Jayadev in California who do a lot of fantastic work, but I haven't heard a lot about that. So I think it's a combination sometimes of resources in place, but also kind of how issues are felt and communicated. And I think we have not done a good job in at least at the ACLU, and then we're trying to change, about communicating the indigent defense crisis. Even the term indigent defense is not an effective term. So it's a huge crisis. And I really think if you want the reforms that we all want on parole, on bail, on policing, you need a vibrant public defense community to kind of effectuate and enforce a lot of those rights. And we just don't have that in so many places.
Awesome. So we're going to open it up to the audience. I see some hands. Do we have a microphone? Yes, we do. And I'm going to ask that folks make sure that their comments come in the form of a question. I know there's a lot of expertise in the room. Folks want to be able to share, but I want to make sure you have the opportunity to pick the brains of these really experienced, excellent panelists. So if we could phrase them in the form of a question, that would be great. Can someone help me? Leah, can you help me keep the stack as far as hands, recognizing the hands? I think this woman right here in the front in the beautiful purple blouse was first.
Hi, is this on? Yes. My name is Suzanne Bergeron. I'm with the National Urban League. I'm with the Washington Bureau in D.C. And we're fighting very hard on the civil rights aspect of criminal justice and ran into some issues with the major bill last year that everybody was on board because of the limitations in terms of its impact on African Americans primarily and Latinos. But this year we had a major forum on indigent defense in celebration of the Gideon anniversary. How can we harness all of you, because you are critical in this debate, to translate your efforts and your advocacy and your concerns and your findings that you're finding at the local level to Congress? I know there's one bill that was introduced on pretrial detention to try to address the money bail issue, but the indigent defense issue is just critical. Have you been communicating with members of Congress? How can we harness all of this documentation of the need?
Just briefly, so we certainly, we have a Washington legislative office, and criminal justice is a big part of its portfolio. And indigent defense is there, and we've tried, I mean, this isn't a very satisfying, we've tried to make Congress care. I'll probably get the stat wrong, but I think, you know, the amount of money that Congress and Department of Justice spend that's available to it on indigent defense as opposed to on prosecutors and policing is just fractional. And so there were some movements, particularly under the Obama administration, with access to justice as part of the Department of Justice, that was really looking at this problem. And so there started to be, I think, a much more productive flow about these no-counsel courts and the role of indigent defense, and also the needing to hear politically the voice of public defenders. I think that has slowed down a bit right now under the current Department of Justice. I don't think that's a priority. And so
I think that's very generous, Zeke.
Well, right. We're supposed to not be that political, I heard. And I think it's hard to get Congress to care about that. I do think that somehow, even though bail is still a hard issue, I think somehow the idea that you're kind of presumed innocent and shouldn't be detained prior to trial has a little more salience than this kind of concept that states have to fork over sufficient money to make sure that people have good lawyers, people who've been charged with crimes, poor people, black people. It's hard to get people to care. So we are trying, but I think part of the effort that I talked about communicating this even to the public includes Congress. And it's certainly not something we're not thinking about, but I don't think we have a particularly dynamic strategy right now to get the federal government to really act on this.
So I'm going to ask people to extend the moderator some grace. I was under the misunderstanding that our panel ended at 10:30. It ends at 10:20. So I haven't been as effective in managing the time. As a result, we got time for one more question. So remember, extend your moderator some grace. We got time for one more question, but these excellent panelists will be around, I think, where they can entertain questions personally. Leah, last question.
Yeah, hi. Sorry. I'll try to be quick. So I guess this kind of piggybacks off of the response that you just gave. So I guess what that brought to mind is the address by Robert H. Jackson on the role of the prosecutor. And, I don't think anybody in this room would argue that we're at a moment of crisis in the indigent defense sphere, more broadly the defense sphere. Given that you don't see it as super salient, I think, to increase the funding to parity for defense and prosecution, I mean, can you elaborate at all on the sort of strategies that you might advocate?
Yeah, I mean, so just when I say salient, that's just I think just realistically, like we are going to keep asking Congress, looking for senators to sponsor legislation that would increase access to justice. I just think that the environment right now is not particularly receptive. But I think that going back to my original point about all the litigation that the ACLU has filed post-Trump, and how none of that is really criminal justice litigation. That's because, as folks here know, criminal justice reform is so local, right? It's inherently local. Police departments, prosecutors, it can be affected by federal policy and federal funding, but it is really change at the local level. And while sometimes that can be frustrating because you want that one case, that same-sex marriage case, you want that one federal bill that will somehow impact all 50 states, the truth is it's also an opportunity, particularly under, you know, an administration maybe that doesn't share all the criminal justice priorities, to go local. And so I think if you look at the political movement around prosecutors, right, and actually getting people out to vote, to know who their prosecutor is and care about it. Like we actually, the ACLU was part of a voter education campaign in Philadelphia just a few months ago, where we went and we knocked on the doors of all of our members throughout Philadelphia and educated them about, and we did it, by the way, the people who were knocking on the doors were all formerly incarcerated people, and they were telling their ACLU members and colleagues about the role of the prosecutor, how important they are, that their decisions, their discretion, their judgment is actually one of the main drivers of incarceration, and kind of explaining to them what we kind of think are the important principles for prosecutors to embrace without endorsing any specific candidate. And the turnout for that race, although still comparatively, you know, humble, was the largest that it's been in 30 years. A progressive prosecutor won that election, who's you know, poised to do really kind of great things. So I think that kind of locally driven change, and then that's the kind of prosecutor that if you said, by the way, the indigent defense problem in Pennsylvania and Philadelphia is they actually, I think, would come out and say, yeah, that's a problem. I want a fair fight. And so I think going that route, and then again, litigation against prosecutors is something that we're thinking about against the bad acting prosecutors. But I think there are lots of ways at the local level to raise this issue. I just think federally, in terms of funding in Congress, I don't see a lot of traction right now.
So if we could take a moment to thank our panelists, thank all of you for coming, and enjoy the rest of your conference.